Washington Debates for the 70s, a series of debates designed to bring together, for an open exchange of views and opinions, outstanding authorities on vital issues facing the world of the 70s. The topic: can regulatory agencies protect the consumer? Here is the moderator, Peter Lissagore.
Welcome to another in a series of rational debate seminars sponsored by the American Enterprise Institute. Our question is, can regulatory agencies protect the consumer? The federal regulatory commissions have been controversial from their creation. They prompt an old question about the extent of the government's role in a competitive system. With the rise of consumer consciousness, the question remains acute and topical. The American Enterprise Institute, a nonprofit, nonpartisan research and educational organization, has brought together two qualified authorities to debate and illuminate our question. They are Manuel Cohen, a former member of the Securities and Exchange Commission from 1961 to 1969, and its chairman from 1964 to 1969. A distinguished lawyer who is now a partner in the Washington firm of Wilmer, Cutler, and Pickering. And Dr. George J. Stigler, a member of the Chicago School of Economics, Walgreen Professor of American Institutions at the University of Chicago, an eminent author and lecturer. We also have a panel of experts, a select group of those engaged in making, teaching, influencing, and writing about public policy, to comment and challenge our debaters. We'll hear from Dr. Stigler first.
I should say that since I prepared my paper, I have become, to my infinite surprise, a member of a regulatory commission. That commission is meeting for the first time tomorrow, so I think it would be premature to say that what I am saying represents the official credo of that agency. In fact, I'm a little worried by the agency because it's called the Securities Investor Protection Corporation, and I somehow associate the word protection with a mafia, but we shall see. Now, let me first say that although I am in general hostile to the use of regulation as an instrument for protecting the individual, whether as a consumer or as a laborer or as an investor or what, I don't want to carry that too far. I am a former college student, not a contemporary college student. I'm not an anarchist. I believe that the requirement of a stable social framework is essential for any efficient economic system. And so, of course, I'm wholly in favor of a regime in which contract enforceability and property right assignments and things like that take place in an orderly, socially determined way. I would in general argue that those policies work best and perform their function most effectively when the main enforcement of those rights and rules is left to the parties of transactions rather than to a group of gentlemen residing in this city. But let me turn now to what are the three main theses of my paper. My first main thesis is that the individual consumer, if he is not hampered, is in general capable of a large measure of self-defense against frauds, mishaps, bad luck, and the like in economic and social life. Not all consumers are intellectually competent and well-informed, but most consumers know how to build up defenses against the many vicissitudes that lie in real life. And it is primarily because we have socially so often hampered his effects that we have injured the consumer. Let me give an example from a field that has nothing to do with the subject which is apparently going to be our main interest tonight, the securities markets. Although I have not, and most of you do not have, the qualifications to judge a good physician, I have no doubt that if we were allowed the choice of hospitals which hired physicians, we would eventually find those hospitals which had established by long experience the credentials of being very good in selecting physicians and supervising their work and then discharging them when they did not do well. The American Medical Association, however, has made it an absolute element of its creed that the corporate practice of medicine not be allowed. In other words, it has deprived the consumer of the main method by which he could, without public supervision, achieve competence in the selection of medical service. The second main point I would emphasize, after I say I think we have a tendency greatly to underestimate the skill of the consumer in meeting the difficulties of our society, is that competition is an enormously powerful protector. That wherever somebody is doing something that is not satisfactory for consumers, there is an offering of profit for those who do a better job. One of the less significant, and I think almost foolish laws of recent times was a full container law. There were people who were concerned over the fact that if you get a box of cornflakes this high, that there are 2 inches of space in the top. And they argued that competition will gradually lead another company to bring out a box in which there's 3 inches of space in the top. And another company, by competition, will bring it to where there's 4 inches in the top. And finally, we will get cornflakes boxes which are empty. I have no objection to that as an argument as to what would happen if that's what consumers want. All I want to say is that then boxes of cornflakes would sell for the cost of the cardboard. And if consumers do want empty cardboard boxes, the market will provide them. And if they want full boxes, the market will provide them. The third and most interesting problem is what is the role of the industry regulatory body. Now, here my thesis is that the industry body, in the long run, must act by and for the industry it is regulated. And not as a matter of venality, not as a matter of lack of integrity or lack of competence, but the political realities of life dictate that the regulatory body become affiliated with and help in what it believes to be the necessary conditions for the survival of its industry. I itemize in my paper a series of what I think are clearly bad practices in the financial community, and in particular in the stock exchange of the United States. One, I don't even consider to be controversial, is the resale price maintenance provision with respect to mutual funds, which says that no one can sell for less than the offering price of the fund, and which is enforced by the federal government, an unusual case of perversity in the protection of the consumer. Now, what impresses me is that this statute, which I won't say that the Securities and Exchange Commission desired, it probably is opposed to it if you get them in quiet rooms by themselves, has been on the books for 30 years in the very sustained program of changes in the law which was requested a year or two ago, and at which time Manuel Cohen was still chairman of the commission. There were serious misgivings expressed with respect to this statute, but even at that time, the SEC was unwilling to come out frontally and say this is an institution that should be abolished and should have been abolished a day before it was put into practice. Others can be cited. I think the collapse of the fixed commission structure, which is full of economic absurdities, such as the absence of quantity discounts, the uneconomic relationship between commission rates and share prices, and the unwillingness to share brokerage fees with non-exchange brokers. The daily collapse of this system is before our eyes. Mr. Hack, a month or two ago, denounced it. Yesterday, the committee of the New York Stock Exchange recommended that perhaps Mr. Dreyfus be allowed into the board, and that's too bad because it would have been a wonderful parallel with French history if we could have had another Dreyfus case. But what I want to emphasize is that collapse and that move towards a partial adaptation of a competitive commission structure is not coming because of the urgent endeavors of the Securities and Exchange Commission. It's becoming because of powerful competitive pressures such as the appearance of the third market. Now, my real complaint is then that the regulatory bodies are not going to protect the consumer. What's worse, they make it very hard for them to protect themselves. They are essentially immune to criticism. I must say that when the New York Times on November 24th ran an editorial saying that the SEC chairman was resigning, that I was duly impressed. They said that at a time like this was on the announced resignation of Chairman Budge, at a time like this, it would be a serious mistake for the President to name as SEC Chairman anyone who required on-the-job training. What needed now is a man who knows the securities industry thoroughly and who can lead it through the kind of change and reforms necessary to restore its health and safety. This is not only an urgent need of the securities industry, but of the national economy. And they forgot to add the sentence, what we need, in short, is a man of the type who carefully led us to the situation we are in at the present time. The industry is immune to criticism. What's most important is it's immune to criticism by the individual investor. If I, as an individual investor, want to find another method of conducting transactions in securities, I basically have to change the law of the land. I basically have to get my congressman, honest Ed Derwinski, to introduce statutes which compel the SEC to compel the New York Stock Exchange to open up freely negotiated commission rates. Well, if I carried that through, and if I lowered my commissions by $5 a year, that would be a very low reward both for Mr. Derwinski and for me. The enormous effort involved in changing a regulatory body means that essentially once you have regulation, the consumer no longer has any defenses. The regulatory body becomes our sole source of defense, and if it fails us in any respect, there are no methods by which the individual citizen can do anything about them. Now, until we can find methods by which we can remedy that, I don't see what our escape is. I'm immensely impressed by the fact that when Mr. Nader's groups, ranging from third-year law students down to seniors in grade school, have completed their studies of each of the fields that they find lacking in probity and elegance, and denounce the regulatory body in violent terms, their infallible remedy is to appoint a new regulatory body which will be composed of better men than the present ones. Well, I don't think the ones in the present ones are bad men. I think we have a system which by itself cannot be changed until we change the incentives and the sanctions of public regulation. As long, for example, as an ICC commissioner will not get reappointed or appointed in the first place if he becomes known as a severe critic of, let us say, the regulation of motor trucking. And as long as the primary parties that appear at the annual appropriations of the ICC are the informed, concerned members of that industry, we are not going to have that regulatory body or other regulatory bodies like that acting in any other than the obvious methods dictated by self-survival. So thank you.
Thank you, sir. And now, Mr. Cohen. I am not an economist, and my remarks may rest too much on legal distinctions. We lawyers have a nasty tendency to be concerned with the rights of individuals, whether the individuals are persons or institutions. Economists, even the microeconomists, tend to give primary emphasis to the aggregate effects of economic activity and to derive principles from such activity. But, and I must make this point, I'm also burdened by another view which colors everything I may say, and that is that in my view, it's as impossible to prove whether or the extent to which regulation protects the consumer as it is to prove whether or the extent to which criminal law and law enforcement agencies protect society. In consequence, I won't try. And I will devote myself, to the extent that I refer to my paper, to the relationships between competition and regulation. I should say about my paper that the one that was circulated to you, unfortunately, was written on a plane coming back from Mexico City between drinks. I have a final version here, which is somewhat more literate and understandable, and I would refer you to it. Now, fair competition is often spoken of as the most effective and the efficient means for allocating economic resources, and the stock market on occasion is particularly referred to as the most perfect model of a free competitive market.
And I suppose, in my simple economics, it's a market in which fluctuation is directly related to the free interaction of supply and demand. Also, markets are referred to as auction markets. The unfortunate fact, in my experience, that all those words do not describe markets as they exist. The stock exchange is not free from government regulation, and indeed, it couldn't exist, at least not as an open and competitive market, if it may be so described fairly, without government regulation. And it's certainly not an auction market, and it's rapidly becoming less of an auction market. Now, the institutionalization of our society, which has been proceeding at a dramatic rate in recent years, has brought with it a number of problems. It's brought with it not only the personalization in our economic sphere of life, but in all areas of our institutional life, and it is institutional, whether it's the university, whether it's a large corporation, whether it's a securities market, or what have you. An individual choice, whether it's investment or other forms of activity, regrettably, fortunately it doesn't apply to sex, is giving away to accumulated effort in the form of institutions, in the securities field, pension funds, mutual funds, insurance annuities, and the like. Now, my thesis can be very simply summarized. In my view, there really is no conflict between regulation of the kind that we are discussing and competition. My view is that regulation is essential to preserve and enforce competition and to ensure that the marketplace operates in the public interest. It's this delicate balancing of the various and sometimes seemingly inconsistent or competing public policy considerations that is the principal object of regulation. I'm not talking about regulation, how the SEC runs it, the ICC, the CAB, or anything else. I'm talking about regulation as a matter of principle. But if we talk about markets, liquidity is often referred to as essential to a strong market, and that it is a factor of competition. Indeed it is, I think. It's essential to competition on the one hand, and on the other, I think it's a result of fair competition. But, and this is where I get to be a lawyer again, liquidity, in my view, in the last analysis, depends upon investor confidence that savings committed to the securities market will be dealt with fairly according to established rules. The law of the jungle, which did exist before there was regulation, where only the biggest, the most sophisticated, or the most unscrupulous could survive, is inconsistent with our democratic ethic of equality before the law and in our daily tasks and efforts. And while I don't think that a reference to the period 1928-29 through 1933 necessarily proves the case, that was a period when the securities markets, at least, were free of regulation. And look what a mess we had. But we have a more recent indication of what goes on. The offshore funds burgeon in an arena almost completely free of any regulation in Europe. Some few years ago, scholars associated with the international organization urged very strongly that some form of regulation be brought to bear on these vehicles. I don't think it's necessary to emphasize too much that the events of the last year have proved the wisdom of their recommendations. But more important from the point of view of our discussion, it has led one country after another in Western Europe and all around the world, North and South America as well, to enact law and regulation which has the effect of curbing competition, a concept which I believe is inconsistent with the basic idea of regulation, which is to preserve it and to make it fair. And when I say fair, I mean competition within and among markets best assures a healthy allocation of savings resources to the various areas of our economy. Back in 1937, which was a fairly early period in the Commission's history, the Commission first expressed itself on the question of competition. And forgive me for reading it, but this is the best way I can get it to you. And I'm speaking about the Commission, not about a personal view. But the SEC said in 1937, and I'll skip some of it, an exchange. They were talking about a regional exchange. And this was in the context of relationship of regional exchanges and the so-called central market in New York. if an exchange maintains a bona fide independent secondary market in a security supported by adequate distribution and adequate public trading activity in the vicinity of such exchange, the round lot trading thereon will determine the price on such exchange. And now we come to the important part. And through the force of competition and the mechanism of arbitrage will have a bearing on the price of the primary exchange. Now, many people have accused the Commission of not understanding the most elementary rules of economics. And I'm afraid to admit, although I must, that on occasion we have not been at the Commission, and now I'm associating myself with the Commission, as bright in this area as we might have been. Now, but that, in 1941, the Commission had a frontal opportunity to deal with this problem, and it did, again. But in this case, it was a rule of the New York Stock Exchange, which would have precluded its members from engaging in securities transactions. I won't go into any details on another exchange. The New York Stock Exchange said no. They passed a rule to that effect. The Commission dealt with that problem and found, and I'll read just briefly a couple of remarks the Commission made. The Commission struck down the rule. The Commission found that enforcement of the rule was not necessary or appropriate to protect investors and to ensure fair administration of the exchange, and it was designed to choke off competition among exchanges. Indeed, the proposed rule probably would have eliminated regional exchanges entirely. But to go on, to get right down to the nub of it, the Commission said that the statute under which it operates contemplated fair competition among exchanges and between exchanges in the over-the-counter market. Quote, a purpose which is closely related to the public policy regarding unreasonable restraints and maintenance of fair competition is declared by the Congress in the Sherman Act. It's interesting to note that in that case, the Stock Exchange urged that its proposed rule was necessary to deal with unfair competition. Now, I have to add, in all candor, having been brought up under the full disclosure scheme, that it's some 30 years since that opinion was written, and there are still restraints that exist, and the Commission has not abrogated them. But again, we're not talking about the particular triumphs or the particular lapses of an agency. We're talking about regulation and what regulation is supposed to be. Indeed, what I just read in 1968 reflected the opinion of the Supreme Court in a non-SEC case in which the court said all administrative agencies must consider antitrust policies among other statutory policies when applying general public interest standards. There have been a series of cases that deal with this problem, and I think that sometime this year we'll have another pronouncement from the Supreme Court which will deal with this particular problem. Professor Stigler made a number of points at page 5 of the statement. The first point was the New York Stock Exchange has imposed and enforced the minimum commission structure. And everybody knows that it's kind of silly. I might add, the Commission knows it's kind of silly, too. The Commission, perhaps, is burdened by the fact that it has to consider the consequences of rapid change. But I think it's only fair to point out that the Commission, just recently, and while I wasn't there, recommended competitive rates at a certain point. Since then, a great many things have happened, and yesterday's newspaper is the latest of that effect. But all of it, I believe, is a result of activities initiated by the Commission some years ago. A special study, the hearings initiated in 1968 looking towards a restructuring of the Commission structure, and that is going on. The fact is that despite what Professor Stigler said, maybe a great many things went on because the Commission did not object to certain things, although it has, as I've indicated, in some areas. But it certainly hasn't been explicit approval. Nevertheless, that's no excuse. Now then, Professor Stigler moved on to mutual fund shares. And he quite rightly, well, first he has 2 points on it. He talks about the front-end loading thing. I should say that he takes issue with the suggestion made by the Commission to forbid front-end loading. And he uses as an argument a typical Stigler rapier-like suggestion that if it's effective, the cost is going to be borne by the other investors. Unfortunately, that's not the case, because the sales charge never becomes part of the investment of the investor. That's separate, insulated. And if there is to be any return of those funds, they do not come from the funds belonging to any other investor. Therefore, the fellow who is prudent to suggest, to use his words, will not subsidize the impetuous, even under the proposal as adopted by the Congress. Now, then Professor Stigler talks about the Commission fixing sales charges and presumably it'd be at 5%. Well, the bill as passed, of course, provides another method for dealing with this problem. But the point I want to make is that the argument 422D, which was designed to support a fledgling industry, now supports a giant industry, about which I hope we'll soon hear more from the SEC. But the argument made in 1940, at the time of this adoption of these statutes, by representatives of the industry was, as the industry grew, competition would force the price down. Fact of the matter is, there has been competition, which I have referred to elsewhere as perverse competition, and the prices have gone up, partly because of this fixed scheme and partly because of the interrelationship of the closed situation in the stock exchange and this 22D. Now, I guess that touches on the point that Professor Stigler made. And maybe I probably exceeded my 10 minutes. So I'll subside at this point, and I have 2 minutes left, I'm told.
The issue has been joined. Dr. Stigler believes that those policies work best which are left to the parties engaged in a free market economy and not dictated from Washington. The regulatory bodies do not and will not protect the consumer in his judgment, and should in fact concentrate on the survival of the industries they regulate. The skill of the consumer in dealing with his own problems is underestimated, in Dr. Stigler's opinion. Mr. Cohen, of course, differs with this view, contending that regulation is not a substitute for competition, but a tool for preserving and enforcing competition in the public interest. While it may be hard to prove the extent that regulation protects the consumer, Mr. Cohen has no doubt that on balance it has achieved its purpose by promoting fair competition in the marketplace.
All right, we're ready for the questions, I'm told. Who'll be first? No?
Dr. Stigler, under what conditions do you feel that regulation is necessary to provide consumer protection?
I think that's too broad a question to discuss usefully. That covers the whole landscape. I think that there may be a demonstrated market failure that calls for regulation tomorrow. We've changed our standards of, let's say, the permissible amount of pollution we're going to allow in the atmosphere, and it may require changes in public policy to affect the change in what we desire. So I really can't effectively answer the question, should regulation be zero or should it be 100% in a large number of industries where some conceivable effects that we dislike are taking place. Since I believe that in general regulation of specific industries, and remember I'm emphasizing that aspect of this discussion, to protect consumers or investors or laborers, seldom ends up doing other than harm to those people. I want to look at the particular proposal in each case and see whether I can find offsetting gains to the substantial loss of competition and the substantial access to the individual to improve his own lot by shopping around, which will normally be lost by the regulatory process. And so I'd much prefer to have you ask me about some favorite form of your regulation if you want to pursue this line.
Going back to the point that you made earlier, you said that the regulator invariably becomes an advocate of the industry in which he regulates. Can the consumer develop a lobby that will be as effective as an industry lobby?
No. The arithmetic of life does not allow it. Lobbies are made up of people who are willing to devote time and resources and votes to activities. Now, an industry can afford to devote those things because let us just take a very striking example of an industry that's regulated, the American petroleum industry. At $5 billion in an ordinary year turns on the import quota system. And that's a lot per worker, per stockholder, major stockholder, and per company. They can afford to take the time to learn the facts, to proselyte votes, to campaign for congressmen and so forth. You and I, who are injured a little by higher gasoline and fuel oil prices and the like, cannot afford to devote the resources even to find out how much we're losing. You can't afford to find out that a law is hurting you for $25. It costs hundreds of dollars to find out. You can't afford to spend many nights sensibly going out and campaigning against a statute that does you harm, as the import quota system clearly does, I think. That would be destroying your home life. You come home at 9, 5 o'clock and say, honey, what things are we being injured by regulators today? And then she'd tell you, and you'd say, I'll see you next Monday. And most Americans have higher goals in life than that. So we can't construct, and I know of no historical example of a viable, continuing, broad-based consumer political lobby.
Washington Debates for the 70s is created and supplied to this station as a public service by the American Enterprise Institute, Washington, D.C. Produced in the nation's capital by Broadcast News, Washington.